So I rise to speak on the Social Security Commencement of Benefits Amendment Bill in this committee stages. And there is, despite it being a very, very small bill, there is quite a bit to say about this. Though it has been pointed out in this House that this is happening through urgency, that it was the provisions in this bill we're being told that they're substantially the same as the provisions that were included in the Social Security Extension of Young Person Services and Remedial Matters Amendment Bill. I sit on the committee. I've been hearing evidence on that bill. These provisions, while some aspects of it are the same, there is detail in this bill that is significantly different. And in this process and consideration of this in the committee stages, we do not have all the information in front of us to be able to debate this properly. We have, as been pointed out, the regulatory impact statement in the original bill made no reference to the provisions in this bill, or indeed in the significant parts of the original bill. We are not able to put the departmental advice that was offered to the Select Committee on the original bill into discussion in this debate because it is still under privilege of the Select Committee. And I did want to bring that into debate, partly because I think it illuminates part of my concerns around this bill and the fact that I don't believe that the principles of transparency and good oversight from Parliament have been enabled through this process. And I would wish for that to be properly debated and considered by this House, because I think it goes potentially to raise some pretty fundamental concerns of the relationship of the Minister and the Department, if nothing else. So what this bill does is that it amends the Social Security Act to correct, we're being told, with retrospective effect to the 3rd of June 1998, an error in the legislation that does not give effect to the policy intent that a benefit commencement on the day after a stand-down period ends as opposed to the day on which the stand-down period ends. So this has been already through the first and second reading of this debate. We have had discussion on that particular point because we are being told that the intent was always for the stand down to end on the day after, despite the fact that the legislation says very, very clearly and unequivocally that it ends on the day on which the stand-down period, the benefit should commence on the day on which the stand-down period ends. I don't believe there's any way of misinterpreting that, but we're being told that the intent was for the next day, and somehow for 18 years this has gone unnoticed, and the policy has been operationalised in a way that does not match the law, that in effect has been a breach of the law. Now, I do admit to there being a possibility, and where this hasn't come to the House's attention or a minister's attention, because it has been pointed out to Social Services Select Committee on numerous times in my short time in Parliament about the problems with the Social Security Act. It is legislation from the 1960s. It has been amended so many times, and there are so many regulations attached to this piece of legislation. It is one of the, if not the, most complicated piece of legislation on our books. It is possible that while the language is absolutely clear, the day on which the benefit commences on the day of the stand-down period ends, that people didn't look at the legislation because it is so complex, and we need to work on that because this is the legislation that enables the most vulnerable people in our country People who, through disability, barriers in employment, are unable to work. People leaving violent relationships. People who have been left responsible for the care of their children and are Mr. Chair.
Jan Logie.
And people who have been made redundant. People who are trying to feed themselves and put a roof over their head when they're not able to be in the paid workforce. This is the piece of legislation that ensures those rights that we supposedly all uphold, those fundamental human rights to food and shelter and the ability to participate in our society, though that has been so hopelessly eroded, that last point. So when the government comes to this House and says that we need to fix a mistake that they have made, we need to look at this very closely. This was brought to the government's attention in May 2014 that they'd got it wrong. And it wasn't brought to their attention just once. It was through 2 rulings of the Social Security Authority that they had it wrong. And if the government then, if you're following the rule of law and the established relationships, the process would have been then for Cabinet to consider that ruling, for MSD to change their practice and to ensure that they were abiding by the law, and for Cabinet then to look at the fact that, oh, okay, we thought there was a different intention to this, and then bring in legislation to change that in the future so that the law matched what they wanted it to do. There is nothing in that good process that says, retrospectively, you deny people access to their rights as they were written in law. And that is really at the heart of what this debate is. And we don't, and I do want to say, I really have such a struggle that the government is saying that they'll give people who have applied, who've had the law misapplied post-May 2014, a period until the 8th of January to be able to get in their review. But people before that date will have no chance of review. Once this legislation passes, that's it. And I've just had an email from somebody telling me, because we've been letting people know about this so that they could get their rights, that review in, because we believed that they should have that right of review as the law guaranteed them. And somebody's just emailed me and saying that WINS is not accepting the documents that have been previously accepted by other officers, and where the people are being paid out up to this point, where they have several WINS officers, I'm being told, are now saying that they, those emails don't belong to MSD, and that they're not accepting them. Now this, this is part of when you're going to cut off a deadline for people that gives people money, that gives people access to a fundamental right by law in this preemptory manner, then this kind of stress and confusion is more likely to happen. And it goes back to my very, very original point of the absolute importance that we seek to ensure people's trust in government. And that trust is being undermined significantly by this legislation and by this process. And that the people who are most effective have already had, many of them, very difficult experiences with the state. And what they're now going to take away from this process is that they were entitled to something, and the government has decided that, well, yeah, you were entitled to it, but now we're going to change the law so that you can't get it. That's what people understand from this. And they will be, on average, so far, the people that have claimed have got $80. That's $80 that can go towards the rent, that could go towards buying a Christmas present for their kid, that could potentially let their kid go to a swimming pool, things we know that families on benefits at the moment are not able to afford. Those absolute basics that when I grew up, I assumed everyone had access to. Of a holiday, of a kid having their own bed, of 3 meals on the table, of a chance for a camping holiday, things like that are not going to be able to be delivered by this bill, and they will not have been able to be delivered by that 1 extra day payment. But the principle is... Chairman.